Restoration application.
Another হলো admission of appeal.
All the list.
একটু দেখাই দিই।
Lordship, I am appearing for the petitioner, Lordship. Item number 1.
Yes. Correction.
Correct.
Huh? All right. Name be corrected. R. Yeah. What do you want? Where will you want to file the bond?
Lordship, first court, but there is in the order as second court, Lordship.
Why first court? The case is before the second court.
No, Lordship, in the order sheet there is a first court, Lordship.
The first court. First court. Next.
Thank you, Lordship. Much obliged.
Lord, do I appear for the petition?
Two.
Lord, I am for the statement.
Lord, my implication arises from a confessional statement of the principal
One
accused.
thing, Lordship has directed personal appearance of the investigating officer. Lord, he is present. Lord, the previous IO met with an accident, Lord. He got the case yesterday. And after getting the case, Lord, he has come before your Lordship. And Lord, just now, Lord, I have received the case hearing, Lord. If I get some time to peruse the entire hearing, Lord, whether CDR is there or not, Lord.
How long are you in custody?
Lord, 30 days.
30 days. All right. Monday.
I'm grateful.
Next.
Monday.
I am for the petition, madam.
Yes.
My petitioner is custody 2 years, 7 months. madam.
Yes. Victim notified?
Yes, madam.
Yes, my lord, we have complied with the petitioner in the crime. In view of the gravity of offense, we are not in.
My lord, nothing.
Next. Yes.
My lord, there are 3 petitioners before your lordship, my lord. All are in custody about 3 years, 4 months, 10 days, my lord. My lord, this is relating to sexual violence cases, my lord. And one of the co-accused granted bail by the learned trial court on 21st of January, my lord. Electricity order, server. And most of the witness examined, there is no possibility of tampering the witnesses. My lord, this is due to political enmity. And accused person implicated in the instant case. One of the co-accused granted bail by the trial court.
All the co-accused were rejected by this court. no?
Yes, madam. Rejected, my lord, same co-accused also granted bail.
My lord,
On
in this case, the order that was passed, CBI was not notified. This is the 6th application before this honorable court. And only 2 witnesses remain to be examined. On to a December, a date was fixed. The defense sought for an adjournment. We need
Mr.
only 2
Majumdar?
days.
Mr. Majumdar, what is the evidence against him? There is
Lordship,
evidence
6 to 7 eyewitnesses and named them
implicated.
all directly.
Petitioners are in custody for
3 years, 4 months.
3 years and 4 months. It is contested. There is no possibility of trial concluding in near future. They have been, they have been falsely implicated due to political affiliation. It is contended there is no possibility of trial concluding in near future. Co-accused Jamanat Ali has been enlarged on bail. They pray for bail. Learned Deputy Solicitor General opposed the prayer. He contends eyewitnesses have implicated the petitioners as members of the unlawful assembly who assaulted charges under 34.
Yes, madam.
Huh? 300 to 34 or 300 to 149. Members of the group.
149, 3 and 4 explosive substances.
149. Members of unlawful assembly who committed the murder. Full stop. Bail prayer of co-accused had been, the petitioners' bail prayer were rejected earlier.
Yes, madam. Rejected.
Bail prayer of petitioners were rejected earlier by this court. Petitioner does not stand on the same footing with co-accused Jamanat Ali, who has been enlarged on bail. He assures the court that trial shall be concluded shortly. We have considered the materials on record. Evidence of eyewitnesses show petitioners were members of the unlawful assembly who had murdered the who had murdered the victim. Full stop. Their bail prayer had been rejected earlier by coordinate benches on merits. Trial judge enlarged Jamanat Ali on noting Jamanat Ali is a septuagenarian suffering from serious ailments. Trial judge enlarged him on bail. Petitioners cannot claim parity as the bail was granted on humanitarian considerations peculiar to Jamanat. Petitioners cannot claim parity. It is also assured that offences, if proved, would attract mandatory life imprisonment. It is also assured that on behalf by CBI that trial shall be concluded shortly. Under such circumstances, we are not inclined to grant bail at this stage. Trial be expedited. Next.
The time for the petitioner, madam, 498, 313, 307, 34 of the Dowry Prohibition Act. Petitioner prayer for anticipated bail was rejected. Thereby petitioner surrendered before the court, madam, 45 days in custody, madam.
My lord, within 1 year of marriage, there is the allegation of extramarital affair. Due to this, my lord, this present incident has been.
What is the
allegation of
material for
313,
313?
No material, madam.
313. Any material for 313?
Lordship, the accused here administered medicine and got the pregnancy aborted. He took the victim to a quack.
Where is the pregnancy? There's some infection.
Yes, Lordship,
They-
the pregnancy got aborted and then Lordship.
Petitioners submit that
They-
petitioner submit he is in custody for 45 days. Allegation of forcible abortion is false. He prays for bail. Learned lawyer for the state opposed the prayer. Learned lawyer for de facto complainant submit. Petitioner was subjected to cruelty and driven out of the matrimonial home within 1 year of marriage. We have considered the materials on record. Petitioner is the husband. He is in custody for 45 days. Full stop. Medical report shows victim lady developed infection and miscarried. No injury, there is no injury, developed infection and miscarried. Allegation that petitioner had administered medicine through a quack to cause pregnancy has to be assessed in the light of the aforesaid medical report during trial. Other allegations of cruelty are general and omnibus. Full stop. Keeping in, there is no chance of abscondence. Accordingly, we are inclined to grant bail. Next.
Lordship, I am for the de facto complainant.
One of the husband of the petitioner and the second wife, they committed suicide by accident.
Who committed suicide? Huh?
Both the victims.
The son and the.
So, husband and of the victim.
First wife.
Muni is the first wife.
Yes, my lord.
Now this man and his he
Second
remarried. They all right. This is a case of suicide.
Lordship, may I,
Ah.
for the de facto complainant, Lordship.
Yes, tell us.
Yes, Lordship, there is a salishi between the first family of the first wife and second wife, Lordship. The accused petitioner herself fixed the marriage with the second wife because she has some disability, Lordship.
What is it?
Lordship, that I'm not aware, Lordship.
So if you are
I-
not aware, the entire
de facto-
foundation of your
Lordship, de facto
case
complaint,
fails.
here, Lordship. Lordship, may I submit, Lordship? On that the such incident has happened, Lordship. On that date, she invited the victim husband and the second wife. When they came for the dinner, Lordship, she insisted her to transfer his property, Lordship.
So
When he denies, then she was murdered. She
It's
was
not
murdered.
murder, it's a case of
No,
suicide.
Lordship, kindly see the photographs, Lordship.
Photographs were zero evidence.
Lordship, kindly.
Let us see the medical, the postmortem report. Yes, cause of death. Then
Lordship, kindly see the photographs.
we are not
That is a part
bothered
of the
about
charge sheet,
Madam.
Lordship.
With folded hands, please prove your photographs during trial.
Lordship.
All right, we have heard you.
One second, Lordship.
Petition, yes.
Lordship, one second, Lordship. Matter was lastly heard on November 20, 2nd November, Lordship. 2nd December, Lordship.
So,
Only 1 month left, Lordship. There is no progress, Lordship, in the trial, Lordship.
bail was rejected earlier.
Yes, Lordship. 2nd December 2024. They went for the dinner, Lordship. Subsequently, at the place,
We
both
won't consider it now. Not pressed.
grateful, Lordship.
Next. Absolutely on time. क्या है, क्या करें? एकदम क्या करें? That's sitting judgment over. All right. How long you are in custody? Petitioner is in custody for 58 days. Whether injuries or life-threatening may be assessed at the appropriate stage of the proceeding. There is no chance of abscondence. We are inclined to grant bail. Next.
But 365 and section 6 of the Pocso Act, petitioner is 21 years and
Notified. We have considered the materials on record. All right, state will inform.
Yes.
Huh? State has informed?
Yes.
Let us see what is the statement. What is the nature of information you are giving? Let us see. Forwarded. What is this forwarded? Where is her receipt? Where is her receipt? One second. Where is her receipt? Whenever we notify, inform your police officer. He has to bring the victim here and you will send her to the High Court Legal Services Committee so that a lawyer appears for her. This is not the way in which the police will intimate. Who has received this notice? Where is the police stating that she was informed that you come, you can participate and High Court will provide you legal assistance? Huh? Tuesday. Report is placed on record. Service is inadequate. Further report be filed Tuesday. Next.
19.
Yes. Same.
Are you including the victim present before your lordship?
Yes, so victim must be represented by a lawyer. Victim is present. Immediately send her to the High Court Legal Services.
Just now she came.
All right. Who is there? Honorable, please appear on behalf of the victim. Who are with the High Court Legal Services Committee?
Yes.
You are there. You are there. Where is the victim?
Sir,
And where
was
is the,
not present. Yes.
huh? She's present?
No, my lord. His signature is there. She received the
Then-
information.
Sir, if the victim does not wish to come, get the endorsement, she is not willing to participate. But otherwise, she should be told that she can participate. It's not just service that you have a notice. Yes, what is this? Parents. Statement of the victim.
Yes.
12 days delay in the FIR. All right. Petitioner submits that there is delay in lodging FIR. They have been falsely implicated.
Now, at page 45, million.
Oh,
Page 45, 164 statement of the victim.
I see.
Disabled lady, my lord. Victim is a disabled, 90% disabled lady.
All right. They have been falsely implicated. They pray for anticipatory bail. Learned lawyer for the victim contends she is a disabled person. In spite of notice, nobody appears for victim. We have considered the materials on record. Allegation of in her statement, the victim's mother stated that petitioners had entered the room and molested her. Full stop. However, there is 12-day delay in lodging first information report. It is contended there is prior enmity between parties. Balancing the submission, balancing the possibility of false implication against apprehension of threat or apprehension of threat perception, balancing the possibility of false implication against the threat perception of similar occurrence, we are of the opinion, though custodial interrogation may not be necessary, movement of the petition.
Charge sheet is not filed, my lord.
Custodial interrogation is not necessary. Movement of the petitioners required to be restricted. Requires to be restricted. Accordingly, would not enter Sahibganj police station.
I'm grateful to your lordship.
Next.
Lordships, the allegations are under section 69, 115(2) and 351(2) of
Victim
the
notified.
Lordship,
And for the de facto complainant.
Lordship, the allegations are
Statement.
completely false.
Statement.
Result of the withheld grudge on the part of the de facto complainant. The
What grudge? Why should the de facto complaint have grudge against you?
de facto complainant got to know each other through the social media.
Social
And other than
media.
that, they had no other connection or no other relationships. It is the victim lady who persuaded the petitioner over and over time to establish any kind of relationship. And when the petitioner rejected,
We have considered the petitioner contents that there was free mixing between two consenting adults. No promise, no allegation that petitioner had cohabited on false promise of marriage is an afterthought. He prays for ancillary bail. Learned lawyer for the state opposed the prayer. Learned lawyer for the de facto complainant also opposed the prayer. We have considered the materials on we have considered the materials on record. Victim is a divorcee with a child. She contends petitioner had promised marriage 3 years ago. They cohabited. Subsequently, petitioner has resigned from marriage. No contemporaneous documentary evidence with regard to promise of marriage is placed on record. On the other hand, possibility of cohabitation out of love and affection cannot be ruled out. Keeping in mind these facts, we are inclined to grant ancillary bail.
grateful.
Custodial interrogation is not necessary for progress of investigation. Next.
Grateful.
My lord, I have on behalf of the petitioner. Lordship, allegation under section 4A, 4C, 52 of Bengal Excise Act.
100 people
Mine-
were seized, my lord, and 1500
Destroyed.
pictures were destroyed, raw material.
But what about the report? What about report? Medical, forensic report, chemical report?
Same is the new case, my lord. Anticipatory bail application,
whether it is harmful for human consumption. Sir, Dishi Mod, Bideshi Mod, whether it is harmful for human consumption.
Report has not been received.
All right, let the report be placed on record. Chemical report be placed on record. Matter will appear 6 weeks hence. Petitioner shall not be arrested for 8 weeks or until further order. If it is harmful, we will not give you. Because that has the potency of killing people. Next.
I'm for the petitioner, my lord. My lord,
Lordship, one day accommodations case date is not here.
Monday.
Monday. Grateful, Lordship.
Victim is there?
no, my lord.
No rape or
Allegation-
anything.
no.
All
Allegation
right,
of
next.
physical- Yes, madam, my lord. I am for the petitioner, my lord. I have started delivered. There is both or major, they have love relationship.
Love, we are rejecting. Too many love affairs.
My lord.
Mr. Nilay Chakraborty is appearing in this matter.
Victim, please intimate victim. Officer in charge, Matabanga Police Station shall notify victim with regard to pendency and a right
My
to
lord, she
legal.
is happy.
Okay, madam. All right, then where is the case diary?
Is with Mr. Nilay Chakraborty. He's appearing in court number 3. I'll just
All right, passed over.
pass over.
Passed over. Next.
25 Lordship, I'm for the street.
25.
Yes, Lordship. Lordship, I am on behalf of the petitioner. The case is under section 108, 77 and 351 of BNS, Your Honor.
77 is disrobing, na?
Voyeurism, Your Lordship.
Huh?
Voyeurism against women.
Voyeurism, yeah.
Lordship, this is a case.
Your son committed yourself. Who committed suicide? With the
Madam,
boy?
Boys,
committed
Your
suicide.
Honor. Your Honor, just see the FIR, there is a delay of 15 days, Your Honor.
All right, let us see. बोलना चाहते हो कि मेरा भाई दीपक शर्मा और सलीना के साथ 10 महीने में मेरा भाई गुमसुम रहता था। यकीन बताने हुआ तब वो व्यक्ति मेरा भाई का मोबाइल नंबर ब्लॉक कर block mobile number, he commits suicide. What is
Lordship, this is the initial stage of investigation.
correct? What will you do with custody? Huh? Luxum? We have petitioner contents. The victim had committed suicide out of depression. Ingredients of offense under 108 PNS are not disclosed in the facts of the case. She prays for hand suitable and a lawyer for the state opposed the prayer. We have considered the materials on record, including statement of the sister of the victim's sister. From her statement, it appears there was a romantic relationship between the petitioner and the victim. Subsequently, victim cut off all association. This prompted the petitioner to commit suicide. Whether withdrawal from a relationship per se would constitute abatement of suicide may be assessed at the appropriate stage of the proceeding. Custodial interrogation for progress of investigation is not necessary. There is no chance of abscondence. Accordingly, we are inclined to grant answer.
Grateful, my lord.
Next.
Much obliged, Lordship.
My lord, I'm not the prime
Yes,
accused
Lord.
named in the charge sheet, in the FIR.
We have
My name
considered the
has come up in
materials on
the
record.
charge sheet, my lord.
Petitioner.
The prime
see-
accused in this case, the two prime accused, Dharmender Singh and Shiv Kumar, was granted bail by this honorable division bench
All right.
on 14/11 on the
All right.
ground, my lord, that there was an infraction of provisions of section 52A of NDPS Act, my lord, where the FSL was, the inventory was sent prior to.
Dhamale's judgment, see now Dhamale's judgment.
Yes, my lordship.
All right.
Yes, your lordship.
52A proposition has been watered down. So we'll look into all that, but now you go into custody.
Yes, my
My
lord.
lord, before
My
your
lord-
lordship passes an order, my lord, an order granting anticipatory bail is already there in favor of this petitioner.
Bojo.
8th of January 2025.
The petitioner appears to have too many friends. Please give the case number.
My lord, CRMA 950 of 2024. And he says this is for the first time he is appearing before this.
950 of 2024.
4, yes.
950 of 2024.
My
Munda,
lord, I was not aware of this.
Justice Kapoor enlarged you on
Yes.
this. Then application, petitioner has been granted anticipatory bail.
I apologize, my lord. I was not aware of
Application
this.
for the present application is not maintainable and dismissed. You're lucky you got the end.
Grateful.
Oh, yes, next matter. Party water. Petition or cut off all. That is what is saying. Yes, yes, next matter. 27. Twenty-seven. Who's appearing? Huh? Yes, Mr. Public Prosecutor. What is 27? Huh?
Acha.
Application का download. ये तो बहुत
কি আছে এটা?
Please, Mr. Nila Chakraborty, instead of talking with him, address the court with regard to what is the state's stance. Not today. Yes, next matter.
28 for the petition, my lord.
Yes.
Actually, my lord, on last occasion, as my mother was hospitalized, I could not.
We are not concerned about your dismissal. We are concerned about the merits of the case. Let me see.
No, my lord,
Let us see what-
I am in custody since last 1 year, 10 months. This case relates to Pocso out of
Restored, we have considered the material.
19 witnesses, 2 have been
Statement
examined.
of the minor
Victim
victim
examined, my lord.
implicates the petitioner in the offence in view of the gravity of offence.
My lord, victim has already
And
been
as
examined.
trial is in progress, we are not inclined to grant bail. Trial be expedited. Yes, next
My lord,
matter.
victim examined, my lord.
Very good. So that doesn't give you a right to bail.
No, no, my lord.
Next. It gives the prosecution a right to convict you and send you to jail for 20 years. Next.
For the petition, my lord. My lord, this is a case
আগে
of
restore করবে তারপর এটা, হ্যাঁ? Yes, section 6.
302, my lord. I am in custody since last 10 months.
Petitioner is restored. Petitioner is in custody for 10 months. What is the evidence against him?
Lordship, 164 statement of the eyewitness.
Statement of eyewitness before magistrate implicates the petitioner in the murder in view of the gravity of the offence, which if proved would attract mandatory life imprisonment and incriminating materials on record. We are not inclined to grant it. Next.
My lord, I'm for the petitioner. I'm appearing online, my lord. This is a matter where item number 30.
Well, it relates to challenge to the notice issued by the jurisdiction assessing officer under section 148 of the Income Tax Act. My lord, whatever challenges the petitioners are basing is on the division bench judgment of the Honorable Bombay High Court in Excise Technologies. That subject matter is now pending before the Honorable Apex Court in SLP.
My lord, they were supposed to submit an affidavit in opposition which has not been filed till date.
And we were
So
directed.
file your affidavit in opposition.
My lord, we just wanted a few days extension.
Deputy Solicitor General seeks time to file affidavit in opposition. Seeks extension of time to file affidavit in opposition. Affidavit in opposition be filed within 2 weeks.
Lordship.
Within 2 weeks, reply to 2 weeks thereafter.
Yes.
Matter will appear 5 weeks hence.
My lord, the stay may be
Just
extended.
for the
The
information,
interim stay.
on 28th, the Apex Court will take up the matter.
Let it be within 5 weeks.
My lord, the interim stay may be extended.
All right, interim order granted earlier shall continue.
My lord, there is no stay there. We were directed not to act upon, not to take any action. We are not taking any action.
My lord, that the date was given till
All right,
24th
interim
January.
order granted earlier shall continue for 8 weeks or until further orders, whichever is earlier.
Grateful, my lord. With your leave, lordship.
Yes, next matter. Thirty-one. Nobody, placed before the next available circuit. 32,
Bring for next circuit.
next available circuit on the prayer of the appellant.
Grateful, Lordship.
Yes, Niloy, the one case diary. Case diary. Yes, they met before Facebook. Is there any post in the Facebook which shows that there was a promise to marry?
As per the CD, my lord.
That as per CD, have you collected the post between the parties during in the association?
No.
Mr. Niloy Chakraborty, now investigation does not require the physical custody of human beings. You require the footprints on their social media that are sufficient to indicate intentions. If their
WhatsApp messages.
yes, a WhatsApp message, does it say that I want to marry you, let's cohabit? There are, it's not that just because two persons cohabit, the cohabitation is because of marriage. That it has to be clearly proved that it was because of marriage. Two persons may cohabit also because of love and affection, isn't it?
My lord, in the WhatsApp message, there's an indication.
Let us see the WhatsApp message. Yes. Love and affection.
My lord.
There is no
So
question
there
that
on
we
the
married.
previous page, the pictures are also there. Some snaps has been collected.
Correct.
Yes, so there is an indication of love.
Nobody denies that there is close intimacy. But the question is, was the close intimacy through a persuasion of marriage? Petitioner contends there was free mixing between two consenting adults. Allegation that cohabitation was on false promise of marriage is an afterthought. He prays for adjudicator bill, learned lawyer for the state opposed the prayer, learned lawyer for de facto complainant also opposed the prayer. We have considered the materials on record, including the statement of the victim.
164.
We have also gone through the messages exchanged between parties on social media platform. taking the materials, reading the materials on the anvil of normal human conduct, we note there was close and intimate relationship between parties. They had promised love, they had promised to be in love forever. However, nothing is placed on record to show that petitioner induced the victim to cohabitation on a promise of marriage. Full stop. In light of the aforesaid facts, we are of the opinion custodial interrogation for progress of investigation is not necessary and petitioner may be granted and sued. That will be in rough forever.
But 27, my lord, the grand 3, my lord, there's no copy, my lord, and my Mr. Bhumik also.
Please see what is there in the records.
Yes, my lord.
You inspect the records, we are keeping 27 on Tuesday.
My,
Go through it, please, if
my-
we'll dispose it of.
my-
All right, it's an old matter.
Yes, my lord.
It's come up.
My-
Thank you.
ছোট নম্বর আছে আমার নিচে ধর
এইখানে যে নোটটা করছি না, এটা কি এটার সঙ্গে দিয়ে দিও, হ্যাঁ? ইয়েস, হ্যাঁ। এটার সঙ্গে।
Yes, my lord, I am for the appellant. My lord, on the last occasion, my lord, I was addressing.
যেখানে ওই ডেপুটি সলিসিটর জেনারেল না জাগরিকে মিসবিহেভিয়ার করেছিল ওই সিকিউরিটি ফোর্স কোড, ওই সব ফাইলটা একটু বাইরে। Yes.
But I was addressing your lordship on the differences between the two honorable judges. My lord, one thing that your lordship has taken, my lord, 19 and 20, whether their evidence can at all be considered or not.
Justice Partho Sen, you indicated PW 14 improbability was referred in paragraph 26.
Lordship.
Then with regard to recovery,
My lord.
paragraph 27 to 33.
Yes,
And in 33, Justice Partho Sen indicates that since place is not noted, it cannot be said to be a discovery state.
Yes. My lord, one more thing.
Can you
My lord.
indicate any specific judgment which will support this conclusion that the place must be shown?
Yes. Yes, my lord. My lord, Babu Sahaba Gowda, my lord, actually says that. Babu Sahaba Gowda. Lord, page number 28 to 30 of my written notes. Running page number, my lord.
Written notes. Yes, Babu Sahib Gowda, you are saying.
My lord.
It is there. 19 to 30. You show us where it's stated.
Lord, the relevant para is paragraph 84, page 29. That is actually an extract of another judgment referred by the Honorable Supreme Court, my lord.
Yes. Page?
Page 29, para 84, my lord.
Yes.
It says, if it is say of the investigating officer that the accused appellant while in custody on his own free will and volition made a statement that he would lead to the place where he had hidden the weapon of offense, the site of burial of the dead body, clothes, etc., then the first thing that the investigating officer should have done was to call for two independent witnesses at the police station itself. Once the two independent witnesses would arrive at the police station, thereafter in their presence the accused should be asked to make an appropriate statement as he may desire in regard to pointing out the place where he is said to have hidden the weapon of offense, etc. When the accused while in custody makes such statement before the two independent witnesses, punch witnesses, the exact statement or rather the exact words uttered by the accused should be incorporated in the first part of the Panchnama that the investigating officer may draw in accordance with law. This first part of the Panchnama for the purpose of section 27 of the Evidence Act is always drawn at the police station in the presence of the independent witnesses so as to lend credence that a particular statement was made by the accused expressing his willingness on his own free will and volition to point out the place where the weapon of offense or any other article used in the commission of the offense had been hidden. Once the first part of the Panchnama is completed, thereafter the police party along with the accused and the two independent witness, punch witness, would proceed to the particular place as may led by the accused. If from the particular place anything like the weapon of offense or blood-stained clothes or any other article is discovered, then the part of the entire process would form the second part of the Panchnama. This is how the law expects the investigating officer to draw the discovery Panchnama as contemplated under section 27 of the Evidence Act. If we read the entire oral evidence of the investigating officer, then it is clear that the same is deficient in all aforesaid relevant aspects of the matter.
But here it does not say that the exact place must be stated.
But indicating the place, my lord.
No, it will lead to the place.
Yes. Pointing out the place where he is said to have hidden the weapon of offense.
He should be asked to make an appropriate as he may desire in regard to pointing out the place.
Yes.
That is all. But let us say this is on the right bank of river so and so. That sort of thing is not necessary. I can show you the place where I have hidden. Now here also he says, I can help you to recover.
But
So it evinces two things. A, his knowledge where the things are kept. B, his willingness to disclose it to the investigating officer. What is lacking is, after this disclosure, the independent witnesses were not present when the
statement was recorded.
statement though already recorded.
Ah.
Again, in their presence, it was recorded. It was not so. On that basis, he was taken and in presence of independent witness. So the absence is actually the endorsement of the statement in the presence of the investigating officers.
Yes.
That is not there. All right. So this is paragraph 84. Para 80. All right.
There are 84 bodies. Lord, and so far as Lord, 19 and 20.
Hmm. 19 and 20?
Yes, so far as 19 and 20, witness number 19 and 20 is concerned. Milord, on
Oh,
the
19 and 20 are the?
Yes, yes. The court 165, invoking 165, Milord, they were.
1920?
Yes. Milord has asked me that I have not taken that point in my written notes. Milord, it is actually not there in the written notes, but in the memorandum of appeal, Milord, I have taken that.
Okay.
And even before, Milord, the division
But
bench.
what we see is the
But-
questions were put by the court, so the leave was sought to be out, sort of.
Milord,
Leave was not asked.
Milord, actually, it is not clear whether the court asks the question or the prosecutor, because normally, Milord, when the court asks, the question is in the question answer format, and to court and the answer in this.
There is no case made out that these questions were put by the prosecutor.
That is.
So we have to, the records show that the questions, that the evidence has been recorded in the form of a statement,
Yes.
which should not have been done.
Yes.
It should have been in the form of queries. If
Queries,
it's a
yes.
court question, it should be court question. And however, since this is, as I say, that we are not going to enter into this, because it seems to be an agreed position that it was questions put by the court, and since leave was not sought, so question of cross-examination does not arise. So since this is the premise on which both the parties have come up, we are not going to reopen the issue that this was a prosecution witness and was examined by the prosecution to prove a fact or prove a document produced. No, it was a court witness. The prosecutor was required to inquire and produce documents. The witness came with the document, court put certain questions or got his evidence, and no leave was taken to cross-examine. So end of the matter. However, can you show us what is more important is 65B certificate. Certificate 65B, Arjun Pandit Rao.
Khotkar, yes.
Now, in Pandit Rao, this judgment is not overruled. Sonu is not.
Sonu is not overruled, yes. But
Sonu not overruled. Now, what will be the impact of Sonu after Khotkar? Sonu is not overruled. Overruled is Tommaso
Bruno and
Shafi
2005.
Mohammed.
Yes.
Shafi Mohammed, Tommaso Bruno are overruled. Sonu is referred. Sonu is quoted.
But Sonu is not referred in Khotkar. Milord.
Yes, it is. Let's go to Khotkar. 40 of your compilation. Bashir is said to be good law and
But it is their page, running page 65, my lord.
It has come. That is what we said. Sonu
Yes.
is referred,
Yes, my lord. It was referred to me.
then it is not over. However,
But nothing has been said by the Supreme Court with respect to Sonu, my lord. I'll tell you.
Sono is in paragraph,
But paragraph. এই গেল,
page,
এই এখানে তো বললাম। হ্যাঁ, বার করলাম। Page 65, my lord. 65. Running page 65. Paragraph 51.
51.
Running page 65, paragraph 51, my lord.
That is irema.
In a recent judgment, the division bench of the High Court held, and thereafter, my lord, in the next para, Sonu was relied. Sonu was the state of Haryana in which it was held.
Right.
51, then next para 16, extract, last line of that, my lord. The court relied upon earlier decision in Sonu versus state of Haryana, 2017, 8, SCC 517.
The issue was completely different, but apart from that, there is no reference to that.
This is what I find, my lord, from the judgment. কতটা বের করা হয়েছিল? কোনটা করে? Thank you.
There are two places in which Sonu is cited,
My lord.
page 50 and page 86 of the original judgment.
Yes.
Paragraph 50. Paragraph 53. That is what you have shown. It's 86. Justice Balasubramaniam, Mr. Conclusion 100, paragraph 120. One twenty.
20.
120. Apart from that, there is no reference. In fact, in Hiremat, the issue was when certificate is issued.
Yes.
When certificate, and there Sonu is referred, but manner and mode of proof. However, reiterating the situation, you will find the interesting judgment on this is later on, where the question was to reopen the issue on Mohammad Arif,
yes.
2023 3
Yes,
SCC 654.
my lord.
That is the judgment, and there they say that there is no question of reopening, but since it's a death penalty case, we have considered it. In your case, the issue of objection being raised or not raised is not germane, because the judge herself had considered the requirement of certification and called for evidence. Right. So the objection, in effect, although not raised, was a matter in issue with regard to admissibility as understood in light of Kotkar.
Yes.
So Sonu
Goes
is
out.
taken care of, subject to hearing the
Yes,
prosecution. All right, we'll consider that from this angle. Then what more?
And my lord, just
The thing is this, Dr. Chaudhary. Even if Sonu, forget Sonu, in light of Kotkar and the evidence of 19 and 20 we hold, these persons are not responsible officers. And therefore admissibility threshold was not reached.
My lord.
We don't look into the CDRs, but the CDRs in effect are corroborative evidence in respect of the substantive evidence of 40. If we believe 14, then the evidence of a phone call is proved through 14. However,
Yes.
proved through 14. And then comes the recovery part. The recovery is through a statement, even if we in Boda it says that the Panchnama was not properly prepared. The fact that there was a statement and oral evidence was given by the IO, how the statement was worked on. And this leads to the recovery of two things. One is a set of jewelry, and one is a cutlery, cookery.
Kukri.
The cookery contains human blood or has human. And the postmortem doctor says that the injury in the deceased are caused by cookery. So these circumstances are against you. These circumstances are against you. We accept that identification of jewelry should have been done and not done to what extent TI parrot will be good evidence has to be seen. And if CDR is not produced, can we totally junk PW14? PW14 is a witness who has no enmity against you. He is a co-driver. And he says, yes, he suggested to me to commit a dacoity and in the house. And I also talked about, made a phone call. The CDRs are not true because of lack of evidence. Will the failure of the prosecution to produce the certification be a remissness in the investigation and prosecution of such nature that it completely improbabilizes the case, or is something which is curable through the oral evidence of 14?
My lord, it could have been curable by oral evidence, my lord, even if we discard the CDR and phone call part. But my lord, for that instance, my lord, the witness, it has to be proved that the witness is truthful witness. But my lord, we have elicited.
What lack of truth? Whether he was going to for the heart, he never say. He said that he carries vegetables. On 26th night, he carried vegetable. Tuesday, there is a heart. 28th, there is a heart. He never says that he goes to heart on 28th. And this is a piece of evidence which really does not impinge on the phone call being made. It's not like he went to the heart and it's something, it just see.
Yes.
There may be a difference when he physically met
Hmm.
at Joygaon. And therefore, his physical going to Joygaon is important. So it is not something which completely renders PW14 a lying witness. It can be explained if the witness is inherently lying and the lie makes him unreliable. But the statement in chief and in cross are explainable. He in chief says he went to Joygaon na Falakata.
Falakata.
He went to Falakata with vegetable. And you ask him in cross-examination that when is the Falakata haat? He says Tuesday and Thursday. And on that you say that why did he take vegetables to Falakata? And he says that I went with vegetables to
Joyga. Joyga.
Joyga on that day. So that
when he was
variation as to where he went
My lord.
does not stand in contrast or contradiction to his having received a phone call. He's having received a phone call. It is completely independent of the incriminating part of his evidence. That is what is going through our mind so far as 14 is concerned.
My lord,
Identification, we agree with you. Certification, we agree. Certification on that will not. It is You want to put in any
Yes, yes, my lord.
additional note?
Yes, yes, my lord, I'll do that.
You please put in the 2023 you cited? Arif
No,
was cited?
no, Arif, I did not cite, my lord, I will.
Yes. Please look into Arif. Certification, Mr. Laksam, you have to explain how certification will be looked. Huh? All right. Mr. Laksam, we keep it on Tuesday? Not Tuesday, sorry. Keep it on Wednesday. Wednesday,
Lordship.
right? We keep Wednesday at 3 p.m. What you do is, you have heard, you prepare your written note and you indicate to us. We want clarification from you on these things. Identification and certification. And why 14 should be. And second aspect, if certification and identification goes away, what other incriminating material is there, whether that is sufficient to establish guilt. Right? If certification goes, still then 14 is there.
14.
So we should believe 14. Why we should believe 14? Secondly, if we believe 14, whether recovery is proved. The second is recovery. To what extent recovery is proved? And in recovery, what are the incriminating facts recovered? Right?
My lord.
There is recovery of jewelry. Now, whose jewelry it has not been proved. Second, there is recovery of a kukri with human blood. Yes, it may not have matched with the deceased, but the fact that it is human blood and it is shown as the weapon, which is corroborating the medical evidence as a probable weapon, is something where there is a chain created.
It was recovered from an open place.
So maybe open place.
My lord.
It does not, there is no allegation of substitutes. And we would have understood open place if there is no human blood, sir. Do you even suggest that the police got human blood, put human blood? Then just think of it, Dr. Chaudhary. There is substitution also. We would have, if the serological report did not say human blood on the kukri, we would have accepted. You can get a kukri from market. But can you get a kukri with human blood from market? That is difficult. All right. You please give any additional. This is your note. Is this your note?
Yes, this is my note.
And this is Laksam's note. But this is whose? For cases referred by state. This is state note. Any additional you want to put in, you can put it.
My lord.
And Laksam, you put in that so that we'll make it CAV on Wednesday.
Lordship.
3, if there is 3, if there is, we'll tentatively keep it at 3 p.m. Okay?
Right.
If our division bench continues, we'll take it at 3:30, but we'll take it up.
Can you pick it on Thursday, Lordship?
Thursday?
All
right.
right.
Thursday.
Lordship.
Thursday. Thank you. Thank you
Grateful.
for your assistance. Eita's সঙ্গে রাখো। Yes, Aniruddha Vishwas, what do you say? You are learning. Do you help Laksam? Help Laksam. What we want to find out is, even if the certification is not there, the CDRs cannot be looked in. Can the phone call through PW14 be relied? This is important. Secondly, recovery, whether PW14 is reliable. Secondly, whether recovery is proved on the showing or on the leading statement. And what is the impact of the signatures not being obtained on the disclosure statement? Apart from Gowda, there are a series of judgments where disclosure statement does not contain signatures. Does not, it is a prudent practice, but just because it is not there, so you have to cite those judgments that yes, disclosure statement recorded by police but not signed by witnesses have been exhibited as disclosures leading to a discovery. Apart from that, what Justice Somen Sen observed that it is also relevant under section 8 as conduct. Then comes the recovery, jewelry, weapon of offense. How much you have proved jewelry is a part of the stolen booty. If you prove it as a part of the stolen booty, you have the advantage of the failure of the accused to explain the death.
1-0.
But if you cannot prove that, you don't have that advantage. But you have the advantage to what extent the blood-stained, human blood-stained cookery, will it lead to a conviction? If we say that whether this is stolen or not, you cannot prove, then what happens? Conviction is under 394.
302.
Only 302, not 394. This we want from you. What you do is, instead of making oral submission, you just jot down these points and supplement. Your note is there, you indicate, we'll finish. Thank you.
Grateful. man.
Please take a call. 3 p.m. call. CV. Yes, CV. একটু বাড়িতে গিয়ে যান। আর অন্যটা আছে না, মিশ্র যোগ্য করলো ওইটা একটু বাড়িতে দেখে নেবো। ওটা তাহলে ডিকটেশন দিয়ে যদি দিয়ে দিতে পারি তাড়াতাড়ি হয়ে যাবে, একটা হয়ে যাবে। থ্যাংক ইউ। উজ্জ্বল লুকসাম।